serious consideration in both the title and commencement of this bill.
Call Eugenie Sage.
Mr. Chair. Colleagues have suggested a number of other names and other titles for the Crown Minerals Amendment Act 2013 Amendment Bill. I think it should be called the Crown Minerals Amendment Act Ignore International Conventions, particularly the United Nations Convention on the Law of the Sea Bill. And here, Mr. Chair, it's a very interesting parallel with another piece of legislation that the House has passed, the Exclusive Economic Zone and Extended Continental Shelf Act. Because in that Act, Mr. Chair, we had a similar debate about, or that bill, insufficient account being taken of our responsibility under the United Nations Law of the Sea Convention, and there it was about preserving and protecting the marine environment. And certainly, Mr. Chair, there are a number of matters in the EEZ bill which decision makers such as the EPA have to take into account, and that includes the protection of biological diversity, but it's got to be balanced off against economic benefits to New Zealand. And of course, Mr. Chair, these two pieces of legislation are parallel because the Crown Minerals Amendment Act Amendment Bill that we're debating today is all about the allocation of block offers and space, whereas the EEZ Act is all about the applications for marine consents to actually do the extraction. And so it's interesting that in both of them we have had this major issue with the government failing to take account of the UNCLOS, the Convention on the Law of the Sea. And here in this bill, and that's because of Clause 14, and the extension of the no protest clause which the Minister introduced with his late SOP into the Principal Act. And it's interesting, Mr. Chair, that the Australian legislation has no equivalent. Certainly there is a 500-metre safety zone around an oil installation, a well, but there's no provision for any safety zone around a vessel. And there's a very good reason for that. That's because UNCLOS does not allow safety zones around vessels, and it's in complete contrast to the provisions around oil rigs, where those are subject to the exclusive jurisdiction of states. But as Duncan Curry noted in his opinion on the SOP to the Principal Act, if you have safety zones around vessels, that creates very confusing zones of coastal state jurisdiction between foreign flag vessels. So this government, in this bill, is overriding UNCLOS, and it shows the contempt with which the government holds international conventions. It's potentially passing legislation which it has no jurisdiction to do, and yet it's being pushed through the House, and we haven't had the benefit of the Law Society, of other submitters who can provide their informed opinion on the impacts of the bill. So, Mr. Chair, I think it should be called the Crown Minerals Amendment Act 2013 Amendment Bill. Take no notice of the international conventions like the United Nations Convention on the Law of the Sea. And that, Mr. Chair, is quite a distressing step because it is showing that New Zealand is risking being a pariah on the international stage, that it thinks it can pass legislation that applies on the high seas, that it thinks it can ignore conventions that have been carefully negotiated, taking into account all of the interests of the parties. And why? To suppress the right to protest. And that is despite the International Maritime Organisation and others and a whole raft of international treaties recognising the right to freedom of association, the right to protest at sea, and the tradition that we have in this country of taking to sea to express our wish to protect our oceans against the dumping of waste, against drift netting, against nuclear testing. This bill is overriding that by extending the provisions in the Principal Act to make it an offence to be within 500 metres of an oil exploration vessel, and potentially quite stiff penalties of imprisonment and very severe fines. And because it goes in breach of international law, this bill is a bad bill, and it is undermining New Zealand's reputation as well as our protection for our oceans.
Jonathan Young.
I move the question be now put.